When it comes to the last 12 months, developments for Vail Resorts have not been what one might objectively characterize as good, but within the past few weeks, the news has arguably gotten even worse. Earlier this month, the company was hit with a multi-million-dollar jury verdict after a serious accident at one of its ski areas. But while the verdict on its own certainly doesn't look good for Vail Resorts, the decision also has far bigger implications for several other high-profile incidents Vail is already facing, and also creates new precedent for the American ski industry as a whole. So what exactly forced Vail Resorts to pay an 8-figure sum within the past few weeks, and what does it all mean, if anything, for the US ski industry going forward? Well, in this video, we'll go through the background of this Vail Resorts case, its decisioning and reasoning overall, and what this all means for you as you go on your next ski trip. Before we jump in, be sure to stay tuned until the end of the video. We're doing a $500 giveaway, and we don't want you to miss out on it. Also, we'll have some information on this year's PeakHouse Southern Colorado trip, which involves a mountain that's very relevant to this video. With that all being said, let's jump right into it. Before we jump into the decision that cost Vail Resorts tens of millions of dollars, it's important to provide some background to it. And this all started with an incident in March 2022, where a 16-year-old skier named Annie Miller was visiting Colorado's Crested Butte, which is owned by Vail Resorts, with her church youth group. On that trip, she and her father attempted to load the resort's Paradise Express quad chairlift, a high-speed detachable lift installed in 1994 that's similar to lifts found at many other destination ski resorts in the country. Detachable lifts are notable for their slower terminal speeds, which typically allows for easier loading and unloading, and as a result, should also give lift attendants more time to spot misload problems. However, something went wrong during this particular loading process. Annie never settled fully into the chair before it left the terminal and began accelerating to full speed, reportedly leaving her dangling in mid-air as the chair kept moving. Her father reportedly shouted for the operator to stop the lift and clung desperately to her arm, but by the time the liftee reacted and actually stopped the lift, it was too late. Unfortunately, Annie slipped from the chair, falling roughly 30 feet onto hard-packed snow, and the impact shattered her C7 vertebra and left her paralyzed from the chest down. In the aftermath, Miller faced a long rehab process and the life-changing reality of becoming a paraplegic. Given the circumstances, her family believed the lift crew had been negligent in failing to stop the chair when it was obvious she hadn't loaded safely. That belief set the stage for the years-long legal battle that ultimately culminated in the landmark ruling we got earlier this year. After the accident, Miller's family filed a lawsuit against Crested Butte and its parent company, Vail Resorts, in Broomfield County District Court, which is the jurisdiction where Vail Resorts' headquarters are located. The suit alleged multiple claims. Number 1, that the resort had breached its duty of care to safely operate the lift. Number 2, that the lift operators were negligent in failing to respond appropriately. And number 3, gross negligence for recklessly disregarding safety. Now, under a situation like this, there are two major defense strategies that a ski resort company like Vail Resorts might rely on. Number 1, the Colorado Ski Safety Act, and number 2, the standard liability waiver included with every lift ticket in the state. Under the Colorado Ski Safety Act, skiers and riders accept many inherent risks of inbound skiing, including weather, snow conditions, and the potential for collisions, and ski areas enjoy broad protections from lawsuits over those inherent risks. Notably, however, that law explicitly excludes chairlift accidents from the definition of inherent skiing risks, so that shield wasn't going to do them much good in this case. The liability waiver provided Vail Resorts with much more solid ground. Like most ski areas, Crested Butte requires guests to sign a liability release when purchasing a ticket or pass product. Vail Resorts' lawyers argued that this waiver, a click-through agreement Miller's father had signed when buying their passes, should bar any claim of negligence relating to the lift fall. For decades, such waivers have given ski resorts near-blanket immunity from lawsuits. One can debate the ethics of it, but it's long been a rule of thumb in the industry that by signing a ticket or season pass waiver, guests give up their right to sue for ordinary negligence on the mountain. And initially, Vail Resorts' liability waiver argument actually held up. In April 2023, a Broomfield County judge agreed in large part with Vail Resorts and dismissed the bulk of the Miller family's claims, including the ordinary negligence and duty of care allegations, leaving only the gross negligence claim intact. In other words, the court ruled that because Miller's ticket waiver warned of risks like misloading or falling from a lift, the resort was contractually protected against standard negligence claims stemming from the incident. Miller's case was not unique in this regard. For many years, many ski injury lawsuits have been halted in their tracks by similar waivers and state statutes shielding resorts from liability for skiing and riding accidents. However, the Millers did not give up. They appealed the dismissal to the Colorado Supreme Court, arguing that a ski resort cannot contract away its legal duty to operate chairlifts safely under state law. They argued that even if a skier or rider signs a waiver, the resort should still be accountable if it violated specific safety statutes or regulations designed to protect the public. This set the stage for a high-profile decision at Colorado's highest court that ultimately led to the multi-million-dollar payout a few weeks ago. In May 2024, the Colorado Supreme Court issued a landmark 5-2 decision that set a new precedent for ski area immunity in the state. The court drew a crucial distinction between ordinary negligence and negligence per se, the latter meaning that negligence based off violating a law or regulation designed for safety. The justices ruled that while general risks outlined in the waiver, such as falls from lifts due to misloading, could still be waived by a contract, a ski resort could not use a waiver to shield itself from liability if it failed to obey safety laws or regulations. This was the first time Colorado's highest court had ever ruled against the blanket enforceability of ski liability waivers, marking a turning point in the state's winter sports industry where a new type of liability lawsuit against a ski area was allowed to move forward in the state. Arguably the main law at issue in this decision was the Ski Safety Act, with a specific focus on its provisions on lifts. Notably, the Ski Safety Act itself contains language that no ski area operator is immune from lift-related injuries, reinforcing that lift safety is a non-negotiable duty. The Supreme Court essentially said that ski areas cannot sidestep these duties with a waiver, because the legislature intended for resorts to be held accountable if they don't follow the rules. 2 justices did dissent on this part, arguing that a signed waiver should block off all negligence claims, but they were ultimately outvoted. For the outdoor recreation industry both in Colorado and in other states, this ruling did not go unnoticed. Liability waivers are ubiquitous not just at ski resorts, but for all sorts of outdoor activities, including climbing, mountain biking, and rafting, and just about any recreation business. In fact, a coalition of youth camps and outdoor outfitters had even filed briefs supporting Vail Resorts, warning that undermining waivers could make insurance unaffordable and force changes that limit outdoor access for kids. But on the flip side, advocates for injured guests celebrated the decision as a long overdue reality check on an industry that had grown too complacent behind its liability shields. As Miller's attorney put it, this was, quote, a victory for ski safety in Colorado, and one that would finally allow a jury to decide if a resort had met its legal responsibilities. But alright, that Supreme Court decision was more than a year ago at this point. And the reason this case ended just recently is because after the waiver circumstances were decided on, the Miller case had to proceed to trial on the remaining negligence claims. After a 2-week trial in summer 2025 with 9 days of testimony, a 6-member jury in Broomfield County returned a verdict in late August. They found that the lift operators had indeed violated industry safety standards, essentially confirming that the resort had failed to meet the legal duty of care required under state regulations. But notably, the jury stopped short of deeming the conduct gross negligence, saying that Vail Resorts hadn't been reckless or willfully disregarding in its safety. This nuance mattered because if the Supreme Court hadn't ruled the way it did, the gross negligence charge would have been the only one allowed to proceed to trial, and the family would have in all likelihood lost the case entirely. But the headline-grabbing metric here is the sheer damage amount. And in this regard, the jurors awarded Miller and her family a total of $21.1 million in damages for her catastrophic injuries. This sum included roughly $5.3 million for non-economic losses, another $5.3 million for physical impairment, and another $10.5 million for future economic losses such as medical care and lost earnings. This all being said, Colorado law did impose a dose of reality on the $21 million award. The distinctions between each of these types of damages is important because state statutes cap non-economic damages at $690,000, far below what the jury granted for pain and suffering. In addition, the jury actually assigned 25% of the fault to the Miller family, essentially concluding that by signing the waiver, and perhaps by Annie's initial trouble loading the lift, the family bore some responsibility. We're not lawyers and we're not going to dissect the logic of how the jury arrived at that specific percentage, but as a result, Miller's recoverable compensation ended up coming out to $12.4 million. While far less than $21 million, this is still a historic sum in a ski lift injury case. It's believed to be the first and only jury verdict against a ski resort based on failing to meet lift safety standards and also symbolically marking a crack in the long-standing armor of liability waivers. Despite public disagreement with the decision, Vail Resorts announced it would not appeal and agreed to pay the $12.4 million, ultimately bringing the case to a close. So with this case decided and Vail Resorts paying 8 figures in damages, what does this all mean for the American ski industry, both in Colorado and beyond? Well, the first thing to get out of the way is this ruling does not mean that other states are headed for a crisis like the one that's been brewing in Oregon over the past several years. In Oregon specifically, state courts invalidated liability waivers entirely. In Colorado, waivers still apply to ordinary negligence, meaning that ski resorts are not on the hook for every incident that happens on premise, provided they follow all applicable laws. And given circumstances that are pretty much unique to Oregon, we'd expect any rulings in other states to be fairly similar to the one in Colorado as well. But what does this ruling mean for you as a skier or rider? Despite all the legal drama, the fundamental skiing and riding experience isn't expected to change dramatically. When asked if the Miller case would alter day-to-day operations, a spokesperson for the National Ski Areas Association said that given the foundational importance of chairlifts, the quote, guest experience is unlikely to change significantly. But where skiers and riders might notice subtle changes, especially at mountains owned by Vail, is in how resorts manage risk on the margins. Ski areas could become more strict with operator training regimens or running lifts on days with inclement weather, essentially erring on the side of caution where in the past they might have previously pushed the envelope to keep guests happy. You might see more signage, announcements, and staff reminders about lift safety on your next ski trip, especially at Vail-owned resorts that will want to show that they are proactively encouraging safe ridership in the wake of all the PR here. But perhaps the biggest change, especially if you are in Colorado, is to your legal rights. As a skier or rider, you've clicked through those liability waivers dozens of times, probably without much thought. After Miller's case, the important thing to understand is that those liability waivers are not absolute for the resorts anymore, at least in Colorado. If, in the unlikely event you or a family member are hurt due to a resort truly failing to adhere to safety rules, there may be legal recourse despite the paperwork you signed. That said, this does not mean that every injury at a ski area is suddenly a ticket to a lawsuit payday. The Colorado ruling was narrow. It allows claims when safety laws are broken, but it upheld waivers for ordinary mishaps and inherent risks of skiing or riding. So if you simply catch an edge and wipe out, or even if you misload a lift and the operator does everything right yet you fall, the waiver will likely still stop any claim you might make. For the millions of skiers and riders likely to hit the slopes in the US this winter, this case probably brings up a number of other questions as well. The first natural concern might be whether riding a chairlift at a resort like this is still safe. Chairlift accidents like this one remain exceedingly rare, and skiing and riding overall are statistically very safe when it comes to lift transportation. It's important to note that the odds of being seriously injured on a ski lift are about 1 in 73 million, which are incredibly long odds to say the least. Modern lifts are built and inspected to incredibly high standards, and serious malfunctions and operational errors are very uncommon. To put it into perspective, you're exponentially more likely to get injured from a bad fall on a ski run than anything involving a lift. The other realm of concern you might have, especially if you're familiar with the Oregon ski scene, might be cost and access. With such a big change to the liability precedent, one might assume that insurance costs will go up, even if the circumstances aren't as extreme as those in Oregon. And if insurance costs do rise for resorts, one would expect that some of that expense would trickle down to ticket prices or season pass costs. But at least for now, we don't think an insurance-driven price increase is likely, and this is in large part given the fact that incidents that aren't directly a ski resort's fault are still covered by liability waivers. However, we'll have to wait and see if any insurers decide to pull out of Colorado in the coming years to know for sure. But where this ruling could have the biggest impact is in what it means for Vail Resorts and its bottom line over the coming years. Now let's be clear, from a financial standpoint, a large company like Vail Resorts is not in existential danger from one verdict. Vail Resorts reported over $290 million in net profit in the most recent 12-month period, and a $12 million payout, while not exactly welcome, is recoverable for a corporation of that size. The bigger worry for Vail is that this is far from the only case related to lift negligence that it's currently grappling with, and in fact, the other ones that it is publicly facing right now might be even more high profile and might be even more clearly their fault. In December 2024, A chair on the Comet Express lift at Heavenly Ski Resort slid backward into another chair, injuring several riders and prompting a federal and state investigation. In February 2025, a chair on the Flying Bear lift at Attitash actually detached from the cable and fell roughly 20 feet, sending the passenger who was seated on it to the hospital. Investigations in both cases are still ongoing, but the early facts in both cases point toward mechanical or maintenance failures that, if confirmed, would almost certainly qualify as violations of tramway safety regulations. That is the exact kind of statutory breach that voids the protection of a standard liability waiver under the new Colorado precedent, and it would give plaintiffs a far clearer path to significant jury awards. While as far as we're aware, plaintiffs in both of those cases were not as severely injured as Annie Miller was, the fact that there were several more people affected across those two cases does play a significant role in how much a potential jury award could be. It's also worth talking about how this comes at a time when Vail's revenue growth has flattened and management has been focused on cost cutting. Even though the company remains profitable, a string of verdicts in the $10 to $20 million range would begin to matter, especially if insurers respond by hiking premiums or pushing higher deductibles. The amounts Vail Resorts pays to settle or litigate lawsuits aren't broken out as a public line item on its financials, but for a company that has spent years squeezing expenses, and had this circumstance come to a head last year when Park City ski patrollers went on strike over a wage raise that probably would have amounted to a couple $1 million cumulatively at most, having to redirect tens of millions of dollars toward legal judgments is probably not what they want to do. But despite all of these less than ideal circumstances, Vail Resorts' valuation could still hold up for a couple of reasons. The company recently reinstated longtime leader Rob Katz as CEO after parting ways with Kirsten Lynch, who notably was at the helm when all three of these lift incidents occurred. Public company valuations are driven a lot by investor confidence in addition to hard quantifiable numbers, so if Katz convincingly pivots the company towards aggressive lift maintenance and visibly safer operations, tangibly making it clear that accidents like this won't happen again, market perception could improve and the company valuation could benefit. However, the reverse is true as well. If Vail Resorts continues to experience high-profile lift accidents, investor sentiment could sour. The Crested Butte case itself took roughly 3 years to wind through the courts, and any future Heavenly or Attitash lawsuits are likely to follow a similar multi-year timeline. Over that period, all eyes will likely be on Vail Resorts to prove that it truly has its safety house in order. It's also worth noting that Vail Resorts is far from the only lift operator that is likely to face cases like this based off the new precedent. In just the past 3 years, the following American ski resorts have had verifiable lift malfunctions that have resulted in injuries to patrons: Big Sky, Montana Snowball, Red Lodge, and Willamette Pass. The latter of these resorts is in Oregon, so it's likely to face that much harsher liability environment specific to that state, but the former three are in Montana. And while it's important to note that the Colorado Supreme Court's ruling is only binding in Colorado, we wouldn't be surprised to see Montana's courts adopt a similar legal framework. We could also see new lawsuits or the revival of old ones in other states testing the waters. It's unclear which of these incidents were caused by negligence on the operator's part, if any, but don't be surprised if some of these cases reach high-profile resolutions in the not-so-distant future. So no, Vail Resorts is not going to collapse from this one multi-million-dollar verdict, but the next 2 years for the company could be pivotal. Colorado's Supreme Court has set new precedent for how negligence per se is treated at ski resorts, and with Vail Resorts still facing at least 2 additional incidents that could presumably involve negligence per se from an operational perspective, the way these are handled could significantly impact the future of Vail Resorts, as well as the American ski industry as a whole. When it comes to the impact for consumers, the decision in this case delivers a clear and important message. Ski resorts are not above the law when it comes to basic safety. For decades, the balance of power was tipped such that injured guests had virtually no chance in court, even if a resort blatantly failed to adhere to safety rules. Now, at least in one state, that balance has been adjusted. What do you think about this development? Anything you're worried about in terms of the implications? Let us know in the comments below. Also, we want to hear from you on the direction of Peak rankings as a whole. And to show our gratitude, we're giving away $500 to one of our lucky supporters. All you have to do is fill out our 2025 engagement survey, which is linked in the description below. With your help, we'll be able to produce content and products that are useful and relevant to you. Speaking of stuff that's relevant to you and this video, we're planning a road trip to southern Colorado this March. We'll be spending a week hitting the best expert terrain at Telluride and Silverton, with an optional addendum to Crested Butte as well. This trip is going to be absolutely insane. with private chalets, a small curated group, and a fully stocked kitchen so you never go hungry. The Telluride accommodation will be ski in, ski out, while Silverton will have an optional heli skiing day. This trip is at the end of March, and it's the perfect way to round out your ski season. If you want to join us before all of the spots fill up, check out the link in the description below. If you found this information helpful, be sure to like and subscribe, and hit the bell so you don't miss any of our content. For more information on skiing and riding in Colorado and over 100 ski resorts around the world, check out peakrankings.com. Special thanks to our Peak patrons, and see you for the next one.